Hi, everyone. Harry here to talk about the Ninth Circuit argument in the case involving whether Trump can federalize the National Guard and send them in to help under the law in question, basically to protect ICE troops and federal property, something that California bitterly opposes. Now, we have a kind of a complicated situation on the ground here. Remember, last week, a district court judge, Judge Breyer, said, no, you can't do that. It violates the 10th Amendment. It also violates just that you don't have the authority because there's no rebellion here, as there has to be under the statute. And rebellion, and this is really going to be the critical question, rebellion is for the courts to determine. I determine that there isn't one here. I go through the definitions in dictionary after dictionary. This isn't big. It isn't armed. It's not trying to take over the whole country, etc. Okay. The Trump administration immediately moves to stay that opinion and really technically to stay the kind of temporary relief, very preliminary temporary relief that Breyer provided. And the Ninth Circuit gave an administrative stay, meaning they put it on hold so they can think about the case more. And now yesterday was when they heard the case. In the meantime, however, Breyer, the district court judge, he is actually the justice's brother, said, I'm going to keep this case because my next step is whether to do a preliminary injunction. We set a hearing for Friday. I'm still going ahead with that. And unless and until, and that's something to really keep our eyes on over the next couple of days, the Ninth Circuit says, no, you're not. The whole case, not just this little preliminary relief you gave, is now out of your hands and in our hands. That's going to happen, and there'll be sort of dual courts, even though one is district court and one is court of appeals. Okay, so the court of appeals, the technical question before them was whether to extend the stay that they've already provided on Breyer's relief. And his basic rationale, and the thing that's really going to matter here, including if and when, and I would say more when it gets to the Supreme Court, is, does Trump get to decide whether there's a rebellion, as there pretty much has to be under the statute? There are a few ways to trigger the statute. This is the kind of obvious one. And does he get to say it, and is it not to be reviewed? Let's talk for a moment about the position that the DOJ took in the arguments in the Ninth Circuit, and it was by a new Trump guy who's sort of head of that division. And they went absolutist, all out. The legal term might be balls to the wall. They said, if Trump invokes and says rebellion, the judiciary can't second guess it at all in under any circumstance. What if, says the judges, it looks like there's really nothing on the ground. As by the way, little aside here, that really is the situation. You've got a fairly calm Los Angeles, and there have been 100 or so arrests, but very much within the ken of the normal law enforcement to handle. And in the meantime, they need the National Guard. I'm here to tell you, as a Southern Cal resident, fires are coming, and, their help is really needed. And if Trump can just say too bad, well, then too bad it is. All right. But the DOJ guy, total absolutist position. What if, said the judges, Trump says, I'm invoking this law, which says it has to be A, B, or C, for reason D, like, and this was the hypothetical, it's Tuesday, something that obviously has no, basis at all, no legal authority at all, and got to kind of, in a way, acknowledge the consistency. The DOJ guy said, that's right. He can do it for whatever reason, including a reason not in the statute, and you can't say boo, judiciary, you can't second guess it. So take a step back and see what's at stake here. If that were really right and their position were upheld, then Trump could kind of do anything, not like what law firms are doing or something in immigration. Call it a rebellion. It's false. It's a lie. but at least the DOJ is saying, too bad, you can't do anything about it. So it's a kind of a breathtaking and almost inherently authoritarian power that they would say that Trump would now get. Okay. The judges, it's a 3-judge panel. 2 of them are Trump appointees. 1 is a Biden appointee. The wide spectrum of accounts of the argument itself made it sound as if the government had the better of it. But I talked about this at length, and if you feel after this summary you want some more detail about this, check out my discussion on Substack yesterday with Adam Klasfeld, who listens to every word. And maybe it's true, but they seemed like basically sort of Delphic. That is, they didn't show their hand one way or another. They just asked certain questions. And it is true that they seemed skeptical of the idea that Breyer had written that you can always second guess and it's totally up to the judiciary. They seem to be inclined towards some theory of deference to the president. Even the Biden judge, in a much noticed back and forth, she didn't talk all that much during the argument, but she did say, I would agree with you, to the California lawyer who was saying that it's the sort of thing that it's for the judiciary, except for this 1805 precedent, which now becomes important in the case. The DOJ guy didn't know it. All kinds of stuff he didn't know. But what he did know is anything involving this law, you have to totally defer to the president. Now, the 1805, just very briefly, case is a guy who there was a declaration by the president that we have a rebellion here, and they were calling up some folks, and the citizen said, I don't care if the president has said it, I get to decide for myself whether there's a rebellion and whether I therefore have to fight. And the courts rejected that. It's not at all clear to me that, as this judge seemed to think, is a really important precedent for saying that you have to defer to Trump here in these circumstances. But that's seemed to be her position. So between her and the other 2 Trump judges, the general take by people who listened to it was, the government is going to win in some fashion. And again, just to note the stakes of a case like this, if they won in full fashion, as the administration is asking, it really would be. It seems to me, Katie, bar the door, whatever Trump wants to say, whatever lie, whatever mischaracterization, he can just say it and nobody can do anything about it. Now, the flip side of the general sense of the commentariat that the court panel was ready to push back on Breyer is that they weren't ready to accept the absolutist position of the U.S., which again is basically Trump says, just invokes 10 U.S.C. 12406. That's the statutory provision that Breyer had said, I get to decide if there's a rebellion, and then we'll take it from there. The panel seemed to be, by, again, the consensus of all the reports out there, unwilling to accept that. But that leaves them in some kind of middle ground. And by the way, this is a case, it seems to me, and a principle that is going to the U.S. Supreme Court. When Breyer wrote his opinion, he made a really good point, which is this is a lot like, in terms of structure, but also just sort of generally, the Alien Enemies Act and the question whether there is a invasion by a foreign country, which seems like, in the case of the members of the Tren de Aragua group. And the Supreme Court said twice, 3 times you could say, by 7-2 and 9-zip, that's for judges to decide. So, Breyer says here as well, this is for judges to decide. And by the way, it's not even foreign policy, really. This is about domestic, when you can do domestic law enforcement. So the Ninth Circuit's going to say something. If you credit the views of all the people who watched, But I watched it myself after, and I think it's not so facile, not so easy to predict. But if you credit their views, they'll have some middle ground that says we don't defer as much as the administration wants, but we do some. But then, of course, at that point, it likely would go, as this is likely to do in any event, to the Supreme Court. So in that sense, what this 3-judge panel in the Ninth Circuit says will matter sort of for its persuasive value or whatever influence it has on the court, but it's the court that really is going to weigh in with the final word on the Breyer question. Do you defer here and give Trump either a lot of running room or complete freedom to, do whatever he wants in the field? And if it's the latter, which is the sort of thing the U.S. is talking about, the consequences, I think, are really pretty grave, because we have a president who would not hesitate, sad to say, to call anything he wants a rebellion if it gives them power. And then we are, pretty close to one channel of unreviewable authority for him, as big as he and wide as he wants to make it. And that's a really, a position that undermines basically democratic rule in whatever settings he chooses to employ. So that's why I think it's worth looking at closely. We also want to see what they do with the Friday preliminary injunction hearing that Breyer still has. But that decision, they've got the stay entered. They didn't seem to be super rushed. They know about the Friday hearing, so you might expect it to come in the next couple of days. But generally speaking, this was not a court that really, notwithstanding what all the comments Terry said, tipped its hand a lot. And I think we got to wait to see what they actually say. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.